There are multiple local, state, and federal authorities that enforce boating regulations, and they generally have the right to board your boat and perform safety inspections to ensure, for example, that every one of your passengers has a life jacket. This can lead to other investigations, searches, citations, and even arrests. Let's hear from an independent program attorney on how this applies in your state.
Going boating is always a fun pastime, especially during hot Florida summers. But nothing can ruin your trip faster than getting arrested while enjoying the day on your boat. A common question we get is, can a Fish and Wildlife Conservation Commission officer just come onto my boat to see if I'm drinking? Well, legally no, but there are 1,000 ways to get around it. When you're driving a car, the police need probable cause of a traffic infraction or reasonable suspicion of a crime to stop your car. The same is not true for a boat. Fish and wildlife officers can stop you to conduct a safety inspection at any time. What kind of safety equipment might they want to inspect? It could be something common, like the number of life jackets on board. But it could be anything: a fire extinguisher, navigation lights, a throwable flotation device, or a rear view mirror. The important issue here is that once a Fish and Wildlife Conservation Commission officer is on board, anything else they observe can lead to further investigation. If a Fish and Wildlife Conservation Commission officer decides to come on your boat for a safety check and then smells alcohol on your breath, you may be facing field sobriety exercises or detainment on suspicion of boating under the influence. In fact, Fish and Wildlife Commission officers are trained to conduct the safety inspections as a field sobriety exercise. Does this mean that you can't legally drink at all while boating? Well, while experienced boaters may agree that drinking any alcohol while boating is a bad idea, the law simply states that you cannot operate a boat while under the influence of alcohol. Under the influence means either having a blood or breath alcohol level of 0.08 or above, or that your normal faculties are impaired. According to Florida standard jury instructions, Florida law defines normal faculties to include the ability to see, hear, walk, talk, judge distances, operate a vessel, make judgments, act in emergencies, and in general to normally perform the many mental and physical acts of our daily lives. If a Fish and Wildlife Conservation Commission officer suspects you of boating while under the influence, they will likely start their investigation with a series of exercises referred to as the Standard Field Sobriety Exercises, or SFSEs. These exercises assist the officer in evaluating whether or not you are under the influence, and the results will be used against you in court. We've all heard of the walk the line test. However, there are a separate series of exercises that are performed while on a boat. It is a common myth that you must perform these SFSE exercises. The truth is, these exercises are voluntary and you do have a right to refuse them. However, under Florida law, your refusal can be used as evidence in a courtroom against you. A Fish and Wildlife Conservation Commission officer can also ask you for a breath test after they have arrested you for boating under the influence. Florida law requires you to take this test if you have been lawfully arrested and it is requested by the officer. Failure to take the test can be used against you in court as evidence of guilt. Further, if you refuse to take the test and you've previously refused to take a lawful test of your breath, blood, or urine, you can be committing a separate crime called refusal, which is punishable by up to 1 year in jail and up to a $1,000 fine. What if you have your firearm in your possession at the same time? Well, Florida law does not prohibit the possession of a handgun while you are intoxicated. Please understand that alcohol and firearms do not mix, but we are simply letting you know what the law says, not recommending that you carry your firearms while you are impaired. In Florida, you can be as drunk as you can get, and it is not illegal to have your firearm in your possession. What is illegal is to be impaired and have your firearm readily accessible for immediate discharge, which is defined to mean loaded and in your hand. Of course, if you do not have a concealed weapons and firearms license, then your firearm must be securely encased while you are out on your boat. Florida law does allow you to open carry your firearm while fishing, but if you are out just cruising on your boat, then the same rules apply as if you were in your car. U.S. LawShield members, if you have any further questions, please do not hesitate to give us a call. We look forward to speaking to you.